I'm Joel Reedy, a founding partner at the Cornerstone Law Firm. Today I want to discuss the differences between a preliminary arraignment and a preliminary hearing. So if you've been charged with a crime in Pennsylvania, these are two terms that you're going to hear fairly quickly. And these are two different hearings that you're going to have in front of a magisterial district judge, or we call them MDJs for short, and you're going to have these two hearings in front of them, and they're important. So what's the difference and what are they? The preliminary arraignment is a fairly simple procedure. It's your first hearing, but it's not a substantive hearing. That is, nobody's going to get into your charges really, or whether you're innocent or guilty or anything like that. This is where your charges are read to you in open court. You do have the opportunity to enter a plea, but in all cases, really, the judge will put in a not guilty plea for you regardless. And you'll also hear about your rights. You'll hear about your right to an attorney. You'll hear about your right to a trial. You'll hear about a number of your other trial rights that are really important to understand. And this guarantees that every criminal defendant understands their rights before the process begins. It's also when they will set your bail, and this is really the most important part of a preliminary arraignment. In most cases, your bail will be set as released on recognizance or an unsecured bail. But if your charges are more serious, you're going to want an attorney present to help you to argue that you shouldn't receive secured bail. That is, you shouldn't have to put money down to stay free while your case continues. The preliminary hearing is really a much more important hearing. It's your first substantive hearing, and it's where you will hear the Commonwealth put together its evidence and present why they believe you should be charged with this crime. And the MDJ, the judge, is tasked with deciding whether they've made what's called a prima facie case. This is just a Latin phrase that really means first blush. In other words, at first glance, is there a case here and should this case proceed? This is really not guilt beyond a reasonable doubt or anything close to it. And you can put on evidence as a criminal defendant, but in most cases you're going to hear what the Commonwealth has to say, and your attorney's job is going to be to cross-examine those witnesses. This is important because it's your only chance, usually, to cross-examine and see these witnesses testify before trial. So your attorney will really want the chance to be present at this hearing and to represent you at it. In some cases, you're going to waive the right to a preliminary hearing. Why would you do that? Well, in some cases, the Commonwealth will come in and they'll say, hey, we've got a deal to offer you, or we're willing to let you on a first-time offenders program in exchange for you waiving this hearing. These are all really important strategic decisions, and you're definitely going to want an attorney present to help you work your way through it at this hearing. So these are the first two hearings that you're going to have in the criminal process, and if you have questions about them, we welcome your call.